Need a quick refresher on English criminal law? You've come to the right place. Welcome to another episode of the Functioning Law podcast, offering a quick introduction to what you need to know about criminal law. I am Theo, and I'm joined by Anna, who is preparing for the SQE. Our material was prepared by Dr. Yannis.
Thank you, Theo. I'll be asking the questions you're probably thinking, and maybe adding a dash of revision-fueled gallows humour. Today we're diving into the absolute fundamentals, aren't we? The very building blocks of criminal liability. Sounds foundational.
Indeed, Anna. Think of criminal law like a meticulously constructed building. You can't just slap bricks together. You need foundational elements, a clear blueprint, and a purpose. Our purpose, in this context, is to provide clear rules of conduct and a fair basis for punishment.
Right, so what are these essential components, these legal bricks, we need to understand for SQE1?
Excellent question. At its heart, criminal liability is built upon two core elements: prohibited conduct, which we call the external element, and the accompanying mental element, the internal element. We can summarize this neatly as prohibited conduct plus mental element equals criminal liability. It's encapsulated in the Latin maxim actus non facit reum nisi mens sit rea.
Ah, the classic Latin. An act is not criminal in the absence of a guilty mind. So that's actus reus for the conduct and mens rea for the guilty mind.
Precisely. Actus reus is the physical manifestation of the crime, the behavior the law prohibits. It can be an action, a specific result, or even circumstances under which behavior becomes criminal. For instance, careless driving is conduct without a designated result, while murder involves conduct leading to a designated result, death. And for something like rape, it's conduct under particular circumstances, specifically non-consensual intercourse.
Okay, so actus reus is what you do or what happens as a result of what you do or the situation you're in. Got it. What about mens rea then, the guilty mind?
Mens rea is the internal, blameworthy state of mind that accompanies that prohibited act. It's rooted in the ethical belief that punishment should reflect what is deserved, requiring awareness and conscious defiance of legal standards. Common mental states that signify mens rea include intention, recklessness, dishonesty, knowledge, and belief. If someone intentionally kills or knowingly buys stolen goods, they are aware of their wrongdoing despite it, and such awareness makes punishment deserved.
So not just doing something bad, but knowing or intending to do something bad. That makes sense for fairness. What happens if both actus reus and mens rea are present, but there's still a reason not to be liable?
That brings us to our third core building block, defenses. Defenses act as a shield against criminal liability, even when both actus reus and mens rea appear to be present. They generally fall into two categories: excuses, where the accused lacked the capacity or fair opportunity to conform to the law, think insanity, and justifications, where the act wasn't wrongful under the circumstances, such as self-defense.
So consent, for example, would fall under negating the actus reus in a crime like rape. Not really a defence in itself, right? Because if there's consent, there's no non-consensual intercourse, meaning no actus reus for rape. Whereas self-defence is saying, yes, I did the act and I had the mental state, but it was justified.
Exactly. A keen observation, Anna. This distinction between offence elements and defences is crucial. And speaking of proof, the prosecution bears the burden of proving every element of the offence, including actus reus, mens rea, and even disproving a defence once the accused presents credible evidence for it. This aligns with the presumption of innocence. The standard of proof is beyond reasonable doubt, meaning jurors or magistrates must be sure of the accused's guilt. If there's uncertainty about, say, the intention in a theft case, they must acquit. Now, let's delve a bit deeper into these elements, starting with actus reus. It's not just about any conduct, but prohibited conduct and the specific circumstances that make it wrongful. The core requirement is an act, which must be an orderly movement coupled with voluntariness. This means thoughts alone aren't criminal, nor are involuntary movements, like reflexes or actions during unconsciousness. Think re versus bratty.
So if I sneeze and accidentally hit someone, that's not battery because it's involuntary?
Precisely. However, Anna, while liability typically requires an affirmative act, omissions can also satisfy the actus reus requirement under specific conditions.
Like failing to comply with a statutory duty or a duty arising from a relationship. So a parent who fails to feed their child could be liable for an omission?
Yes, that's correct, provided the omission was voluntary and directly led to the prohibited harm. Other exceptions to the Act requirement include possession offences, like possessing prohibited items, and situation liability, such as public intoxication.
That makes sense. So it's not just about what you do, but sometimes what you fail to do when you have a duty. What about causation? That always feels like a bit of a mind bender in problem questions.
You're right. Causation is a critical aspect, particularly for result crimes, which require proof of harm resulting from the defendant's wrongful act. The prosecution must prove that the defendant's actions caused the prohibited result. We use a chain of causation to link the defendant's conduct to the eventual harm. The defendant's wrongful act must remain a substantial and operative cause.
And if something else happens that breaks that chain?
Exactly. A subsequent act or event can break the chain of causation, rendering a finding of accountability inappropriate. Causation involves two components: factual causation and legal causation. Factual causation is often tested by the but-for test. Would the harm have occurred but for the defendant's conduct? Think R.V. White.
So if I poison someone, but they get hit by a bus before the poison takes effect, I'm not factually the cause of death by poisoning, even if I intended to poison them.
A morbid but accurate example, Anna. For legal causation, the defendant's conduct must be a substantial and operative cause of the harm, even if other factors contributed. And, to your earlier point about breaking the chain, acts of third parties, negligent medical treatment, though this is rare, unforeseeable victim actions, or independent events like natural disasters can break the chain. But remember the thin skull rule. You must take your victim as you find them. Their pre-existing vulnerabilities don't break the chain.
So, with recklessness, you have to see the risk and just carry on anyway. What about negligence? Where does that fit in?
Negligence is a form of objective fault, where you fail to exercise the care expected of a reasonable person. Unlike recklessness, it does not require awareness of the risk. It's primarily applied in offences like careless driving or gross negligence manslaughter, where the conduct is so deficient it justifies criminal liability.
Okay, so intention, subjective, highest blameworthiness, conscious aim or virtual certainty; recklessness, subjective, conscious awareness of unjustified risk, proceeds anyway; and negligence, objective, failure to meet reasonable person standard, no awareness required. That helps clarify the hierarchy.
A fundamental principle ensuring fairness in criminal liability is the coincidence of actus reus and mens rea. This means the external element and internal element must align in time and correspond in substance. The defendant must possess the required mental state at the precise moment they perform the wrongful act.
But what if they don't? Like, if someone sets fire to a mattress accidentally, then later, after the fire starts, decides not to put it out?
That's the R.V. Miller 1983 scenario, a perfect example of how omissions can circumvent the temporal coincidence rule. His failure to act became the actus reus, coinciding with his later recklessness. Similarly, with continuing acts, as in Fagan v. MPC 1969, an initially unintentional act can become an assault if the mens rea is formed later while the actus reus is still ongoing.
So the court looks at the whole sequence of events as a single transaction to make it all fit?
Precisely. This also applies to the so-called supposed corpse cases, where the defendant mistakenly believes their victim is already dead, but then does something else that actually causes death. The courts often treat the entire sequence as a continuous chain. And then we have the correspondence principle. Each element of the actus reus should align with a corresponding mens rea. For example, in theft, you need dishonesty and intent to permanently deprive.
What about transferred malice? That one sounds a bit like something out of a fantasy novel.
Well, while this sounds dramatic, it's quite a practical legal doctrine. Transferred malice ensures criminal liability attaches even when the actus reus affects an unintended victim, provided the mens rea aligns with the act. In Latimer, 1886, the intent to strike one person transferred to an unintended victim. The crucial point is that transferred malice only applies within the same crime category.
So if I intend to hit a person, but accidentally hit a window instead, my intent to harm a person doesn't transfer to criminal damage to property. That's Pembleton, 1874.
Exactly. You understand it perfectly. It's about matching the type of intent to the type of harm caused. We've laid the groundwork, so let's briefly touch upon some key crime categories and defenses you'll encounter. For homicide, we primarily deal with murder and manslaughter. Murder requires the unlawful killing of a human being with the intention to kill or cause grievous bodily harm. Voluntary manslaughter is murder reduced by partial defenses like loss of self-control or diminished responsibility. Involuntary manslaughter covers cases where there's no intent to kill or cause GBH, like reckless manslaughter or gross negligence manslaughter.
And rape, that's all about consent now, isn't it?
Absolutely. Under the Sexual Offences Act 2003, consent is defined as agreement by choice with freedom and capacity to make that choice. The absence of consent is crucial. And don't forget the conclusive and evidential presumptions under Sections 76 and 75, which can establish or imply a lack of consent in specific circumstances.
The non-fatal offences against the person, assault, battery, ABH, GBH, those are all about levels of harm and intent, right?
Precisely, from mere apprehension of violence in assault to breaking both layers of skin for a wound in Section 20 GBH. The key is differentiating the required mens rea for each. And remember, consent generally serves as a defense only to common assault, not more serious offenses, unless in very specific, privileged contexts like surgery or sports.
Okay, what about theft? That's a big one for SQE 1.
Theft is defined in Section 1 of the Theft Act 1968. The actus reus involves appropriating property belonging to another. The mens rea requires dishonesty and an intention to permanently deprive the owner of it. And remember, appropriation can even occur with the owner's consent, as in Gomez.
And burglary is basically theft, but in a building.
Not quite. Burglary involves entering a building as a trespasser with the intent to commit theft, GBH, or criminal damage. It's about the trespass plus an ulterior offense, distinct from theft itself, which focuses on the dishonest appropriation of property. Then we have fraud, which encompasses various forms of dishonest representation or abuse of position aimed at gain or loss, and criminal damage, which covers unlawful destruction or damage of property, with varying degrees of mens rea for simple or aggravated forms. Finally, a quick word on defenses and other forms of liability. We distinguish between failure of proof defenses and affirmative defenses. Failure of proof defenses, like intoxication, automatism, or insanity, negate an element of the crime, leading to an acquittal. Automatism results from an external factor, leading to absolute acquittal, while insanity stems from an internal disease of the mind, leading to a special verdict of not guilty by reason of insanity.
So with automatism and insanity, it's about whether you couldn't form the mens rea because you weren't in control, and voluntary intoxication generally isn't a defense, especially for basic intent crimes, because it's considered reckless?
Precisely. Involuntary intoxication, however, can negate mens rea. Then we have affirmative defenses, such as self-defense, duress, and necessity. These concede the actus reus and mens rea, but argue the actions were justified or excusable due to external circumstances. Self-defense permits reasonable and proportionate force to prevent crime. Duress applies when criminal actions are coerced by threats of death or serious injury. Necessity justifies conduct undertaken to prevent a greater harm.
These are definitely critical for problem questions, trying to spot which defense applies. What about people who help commit crimes or try to but fail?
You're touching on participation in crime. Think accessories who aid or encourage, and criminal attempts. For attempts, the act must be more than merely preparatory to the substantive offence, and the accused must intend to commit that offence. Interestingly, criminal attempts are liable even if the offence was factually or legally impossible.
Wow! That was a whirlwind tour of criminal law fundamentals. So much to absorb, but breaking it down into actus reus, mens rea, and defences, and then looking at specific crimes with that framework really helps.
My pleasure, Anna. The key for your SQE preparation is to approach each problem question methodically. First, identify the prohibited act, the actus reus. Second, determine the required mental state, the mens rea. And finally, examine whether a defense applies to block liability. This structured approach ensures clarity and confidence.
That's fantastic advice, Theo. A clear framework is exactly what we need when the pressure's on. And speaking of clarity and confidence, remember, if you want more insights and practice questions to solidify your understanding of the FLK, make sure to subscribe to Dr. Yannis's MCQ SQE newsletter. It's packed with useful resources.
Indeed, and for visual learners, do check out the YouTube channel for more detailed explanations and case studies. It's a great way to reinforce what you've learned here.
And if you found this episode helpful, please do us a huge favor and hit that like button. It helps spread the word and reach more SQE candidates who need this vital information. Every like helps.
Absolutely. Thank you for joining us today on the Functioning Law Podcast. Keep studying diligently, and remember, a systematic approach will always serve you best.
You've got this, future solicitors. We'll catch you next time.